We'll now be moving to the last panel, and reports we heard from the hubs and your presentation are a perfect introduction to it. It will be moderated by Judge Tim Ike and myself, and I will hand over in a minute. We will first hear from our panelists who will look to address what they've heard from the national hubs, and then we will go to all hubs and ask you kindly to prepare one question each, so that we get to address questions from all the hubs, and then that we also give chance to judges who are here in the room with us to comment as we are looking to wrap up the forum. So Tim, over to you.
Thank you very much, Biljana, and let me join you in thanking the hubs for the feedback and the reports this morning, which were very instructive. As Biljana said, we will start by asking the three panelists in turn to comment and reflect on what we heard this morning before we then open up the questions and comments to the hubs. As Biljana said, one short question, if possible, please, and I will take the hubs in reverse alphabetical order to ensure fairness. And therefore, without further ado, I will ask the President of the Court, Judge Robert Spano, to give us his reflection on this morning's reports.
Thank you very much indeed, Tim. I would begin also by thanking all the hubs for their presentations this morning and their reflections, which were very important and very informative for us as well, and some of which I want to comment on. One of the running themes this morning was a topic of great importance for the current landscape in Europe when it comes to judicial independence, and that is the question of judicial expression. I want to break that down a bit because I think it is important to identify what we are talking about when it comes to judges themselves using a right, which they have like any citizens, but when it comes to judges, needs to be qualified. The first type of judicial expression, which I think we should identify, is judicial expression in the pure professional sense. When a judge renders a judgment in a panel or by him or herself, he or she is, of course, doing his or her job, but is at the same time expressing to the outside world a particular viewpoint. It is a legal viewpoint. It has a judicial binding effect. Now, that viewpoint, in general, is untouchable in a sense that in almost all circumstances, judicial expression stricto sensu will not be the basis for any proceedings against the judge, him or herself. It falls under the judge's very strict functional immunity. We have seen recently some attempts to begin or potentially commence disciplinary proceedings on that basis. I caution every type of measure in that regard. That is very, very problematic in my view from the perspective of the Convention. But that is what was not the focus point this morning. The focus point was a second type of expression by judges. It is when a judge takes part in societal debate or indeed performs an expressive activity vis-a-vis colleagues or the institution of judges. There I would mention that although it is true that the European Court of Human Rights has in Baka v. Hungary made clear that judges expressing themselves either on the basis of a statutory duty, as András Baka did as president of the Supreme Court of Hungary in that case, but in general, for example, we on the bench here today and so forth are taking part in a general societal debate about the judiciary. Those types of expressions are in principle safeguarded by Article 10. However, you may recall that under Article 10, paragraph 2, there is a particular limitation on that right, which is aimed to maintain the authority and the impartiality of the judiciary. Now that, of course, applies to judges themselves. So then we turn to the third type of expressive activity. That is when a judge begins either in oral form on TV or, as is now becoming more frequent, by the use of social media, discussing pending cases, or criticizing ad hominem particular judges or particular judicial decisions. In my view, that is not acceptable. That is not in conformity with any acceptable view of judicial ethics. Now, we, the court, the European Court of Human Rights, have been mindful of the need to demonstrate an example in this regard. And this is what we have done very recently by our renewed or reformed resolution on judicial ethics, which came into force a few days ago on the 1st September 2021, and you can access that resolution on the court's website. Rule 7 of that resolution discusses expression and contacts, and discusses exactly the issue that I just mentioned, and in my view sets forth a standard which there is no reason to consider this should not be applicable, or at least taken into account in judiciaries in the member states. When it comes to social media, there of course views can differ, but judges tweeting about cases, or judges tweeting or criticizing their colleagues, I say this, and I'm pretty sure most judges would agree, that is not acceptable judicial behavior. That is not the way judges can interact with the outside world. The second point I wanted to make before I conclude my part is the overall issue of judicial reforms, which is of course very pertinent for the region. There is a challenge here that I'd want to mention, and it is a jurisprudential challenge. It is the difference in approach which may be developing between the European Court of Human Rights and the European Court of Justice for very logical reasons. My counterpart in the European Court of Justice has publicly stated that the approach taken by the European Court of Justice under Article 19 TEU and Article 47 of the Charter is what he terms a contextual approach. And what does that mean? That means that a judicial reform mechanism for one state is not necessarily applicable or suited to another state. In other words, the European Court of Justice will take account of history, traditions, the way in which the separation of powers has developed in a particular state. As I think some of my colleagues mentioned yesterday, that may have consequences for final outcomes in certain cases. But remember, the European Court of Human Rights is a different institution in the sense that it develops and interprets minimum standards which are applicable throughout the 47 member states. The way in which the court can take account of contextual factors in formulating the minimum standard may be, to some extent, more limited than we can see in the EU system. But again, that is a logical view due to the fact, as recounted in Article 52, paragraph 3 of the Charter, there is nothing as such to preclude the EU from imposing higher standards than under the Convention. But coming back, I do think, however, and as I've said before publicly, that the two courts should strive as much as possible to continue to find normative harmony in this field. Thank you, Tim.
Thank you very much, Robert. And perhaps just your first point, of course, again, highlighting the point Judge Lemons made yesterday about the two sides of the coin, the duty of the system, but also the duty of the individual judge to behave in a way that is judicious. Without any more, can I then pass the floor to my former colleague and my former section president, Mirjana Lazarova-Trzaskowska, to give us her reflections.
Thank you, Tim. Well, first of all, I will also like to express my thankfulness to HUBs and to their contribution. It was really a pleasure to see many of my friends in the region. I hope that we will have a chance to meet in person in probably next year, I hope. But like most of my colleagues, I have my written comments, but now I will speak by heart because I was inspired by my friends and colleagues from the hubs, because the topic of this panel does cover most of the issues raised by them. But let me remind you of the opinion of the Council of European Judges from 2001, which does stress that to fulfill its role, the judiciary must be independent, and independence thus serves as the guarantee of impartiality. This has implications necessarily for almost every aspect of a judge's career, from training to appointment and promotion and to disciplinary. And that's why we are discussing now in this part of the panel not only the transparency and publicity, but also training and ethics, because it goes hand in hand with all aspects of independence and impartiality of judges. Much has been said by previous speakers and by Thomas about the work of the Venice Commission, and I know that the courts in the region are relying on opinions and on consultative role of the Venice Commission, but also their eyes are always turned upon the case law of the European Court of Human Rights. And when it comes to the role of the judges and their appearance in public, of course, we should look above Baca versus Hungary, because as it was already mentioned by President Spano, it's one of the most relevant judgments for the independence and impartiality and visibility of judges. Judges should be aware about the processes which are going on into the society. They should try to participate actively. Associations were mentioned by some of the hubs this morning. This is one of the forms to be active and present in society. And other forms are judicial and media council, the model from my country, from the north of Macedonia. And also, I think that Serbia was mentioning that they have a strategy on media communication. So things are happening, things are going on, even despite the reforms which are going on in the last 13 years, still we need to look above positive and good practices in the region. So that's why I'm mentioning these processes. Also, don't forget the case of Laura Kövesi versus Romania. This is, of course, one of the key cases nowadays when we are talking about independence of judicial system and the importance of the judicial system in our society. Not only judges, but also public prosecutors are under the pressure of different elements in the society. I will remind you also on the case of Maurice versus France, equally important case for the proportionality and also for the role of the judiciary into nowadays society. When we are talking about publicity, the publicity is not always being present in media, or it's not always in presenting the case in media. The publicity might be achieved also by organizing events like this, open for public. The publicity from a side of judiciary might be achieved also by judges who will from time to time introduce in front of the public important judgments, who will come in front of the public with legal summaries, introducing the key elements behind the judgment. Another element that was mentioned in several hubs this morning, and I consider this as extremely important, is the perception of public of justices or of judges as corrupted, and the low level of trust toward courts and judges. This is a huge problem, especially when we have a situation where the researches, as it was mentioned by Professor Prešova, are pointing out that there are not so many cases against individual judges, but the public perception is still extremely negative. And I think in this field, we will have to work more on transparency and publicity, and the judges itself will have to work on improving the image of judiciary in public, because through our judgments, which should be with clear legal standing and with good explanation behind it, but also to our public appearance based on ethical codes and based on clear judicial knowledge, which was mentioned yesterday as one of the key elements for protection of integrity and independence of the judges, we will achieve probably better results how we are seen from external. It's important to work with outside public, not only to work inside in the judiciary. So I will stop here, and of course I'm open for questions, and I'm looking forward for discussion. Thank you.
Thank you very much, Mirjana, and without further ado, hand over to my former colleague, our former colleague, Judge Lady Bianca.
Thank you, Tim. I also thank the different hubs for contributing to this debate, and we perfectly understand the interest in specific capitals of the region about this issue, which is a very tricky issue for the operation of the judiciary. I will speak according to the program on the role of the other state institutions, and I'll divide it in 2 points. The question first of the personal interference from other institutions into the work of the judiciary, and the second one is the institutional interference from other institutions in the work of the judiciary. The question of the personal interference was very much elaborated today by my colleague Johan Ilievski in the presumption of innocence debate, and it goes very much into that point. However, the issue in the region, as we know, is very much problematic. For illustrating the issue, I'll mention you a story which is kind of 20 years ago. I came across of an obituary of a French politician, and reading the newspaper, I said, well, I know this name. His name was Michel Poniatowski. Probably some of my colleagues would remember that. And the newspapers were referring to the fact that he was, for example, the mastermind of the victory of the French presidentials in 1974, Minister of Interior, EUMP, etc., one of the main French politicians. However, said the newspaper, he will be mostly remembered for the fact that he issued a declaration in the public violating the presumption of innocence of Alain de Ribemont. So the big case on presumption of innocence, Article 6.2 of the court. So this brings me to the situation in the region. I'm not sure that regional politicians will be negatively remembered of their political career of violation of presumption of innocence. I might even say they might be praised, what we see in the region. So there is a increased risk in the region of these statements by the political personalities in the work of the judiciary. Then I move to the issue of the case law of the court in this relation. In the guide, you have a brief elaboration of the statements which might be prejudicial, and you have the 4 elements which are elaborated in the guide. I will not go through it for question of time. I only mentioned 2 cases which I consider very important in this regard. I would refer to the case of Gutsanovi, because the readers of the guide might find it interesting, because there are 4 public personalities, judge, prosecutor, minister, prime minister, making statements in different stages of the proceedings. And I would even invite to read the full judgment when you are interested to this issue, because the the judgment kind of navigates towards identifying where the problem might lie in the wording of the statements, in the time when the statements are pronounced, by reference to the judicial proceedings. So I find this judgment very interesting in this regard. And the second one I would mention is the case of Konstas versus Greece, where the court said specifically that the Minister of Justice has a very special role and should be extremely careful when making statements, because the role of the Minister of Justice and the relation with the justice system is quite particular. Then is the second part of my intervention, which is the institutional involvement of other institutions. Two brief steps. First is elaborated in the guide, and which is the role of the Parliament and the Executive vis-à-vis the product of the judiciary, which are the judicial decisions. In the region, we find, and there are violations concerning all the countries concerned, the non-enforcement of judicial decisions by the legislative and the executive, including, I might say, a non-enforcement of Strasbourg Court judgments by the several governments in the region. I also would remember the fact that, because it goes very much to the legacy in the region has had in the codes of criminal and civil procedure a special provision, which is Soviet-type procedure. The review of a final court judgment, because of the intervention of political body, Prime Minister, President of the Republic, etc., and the competence lied either with the President of the Supreme Court or with the General Prosecutor. Issues that have been dealt by the Strasbourg Court in Bukov, in Brumaresco, and etc. Still, this is kind of part of the mentality in the region, and we find instances of such interferences, JRA versus Albania, for example, etc. And then the second point, the second part of my second point, is the issue of the judicial reforms that also President Spano mentioned. It was mentioned also by other interveners that there is a risk in Europe, especially by populist movements, to put the judiciary under control. There is a risk, President Spano said last November in the Committee of Ministers meeting, that governments try to pack the courts. And this is quite present in the region, in the wider region, I might say. There is a very good study by Cristina Dallara, a specialist on the judicial reform in the region, and she refers especially to the issues of legacy and these attempts to control the courts. However, the court in Strasbourg has been careful to these attempts, starting with Baca and following with other cases. I would only underline a specific issue which judicial reforms have been kind of brought to, which is the issue of the kind of blocking the operation of the judiciary, as it was the case in Albania, which as an issue might bring to more human rights violations and not to more human rights respect. The issue was underlined last year by the Venice Commission and by our former colleague Angelika Nussberger in her report in relation to Albanian Supreme Court. And unfortunately, this June, the Albanian Supreme Court has replied that to applications concerning length of proceedings before the Supreme Court, has replied that we are conducting a judicial reform, so all delays are justified. This is the issue where the judicial reforms should be conceived, drafted, and implemented in a way to respect human rights, not in a way to violate human rights. So the judiciary, in raising the issues, but also the parliaments and the executive, when they draft, when they conceive, when they implement the judicial reforms, they have to be very careful in order not to bring to a total halt of the judicial operations, especially Supreme Court and Constitutional Court, as it was the case in Albania. And I'm happy to reply to any questions that might be raised. Thank you.
Thank you very much, Lady. Before we move on to the next part, you invited those who are interested to read Kutsanovi, and I just wanted to point out that apart from available in the two official languages of the court, there are also on the HUDOC website non-official translations into Albanian, Bosnian, Macedonian, and Serbian for those in the hubs who want to access them in a language that is in their own language rather than in one of the official languages. Thanks to the exemplary, more than exemplary timekeeping of this panel, we have in fact gained 10 minutes in order to enable a broader and deeper, I hope, discussion with the hubs. And what I propose to do now is to, as I said earlier, invite the hubs in reverse alphabetical order to pose a question or make an intervention. And I will take the first four and then ask the panel to respond, and then take the remaining three, and then we will see where we are, and I might invite the room to comment too before we then, if we have time, open up again. So can I first then call on Zagreb to pose a question or give us their response or thoughts? Briefly, please.
Thank you very much for giving us the floor. We could inform you that for now on we don't have a question, so I think that you could ask another hub if they have a questions. We were listening you carefully, and I think we still need some time to think it over. Thank you very much.
Thank you, Zagreb. The way we're going, we may well come back to you, so if you have questions. I will then move on and ask Tirana whether there are any reflections or questions Tirana has in response to what they heard this morning and from this panel.
Thank you. We have two questions from one of the participants here in the panel. Thank you.
Hello. Thank you very much for organizing all of this and having the chance to make this kind of discussions in such a renowned panel and also in such a great group here at the hub in Tirana. I have two questions. One, as we know, in Albania we always say that we have excellent laws, very good ones, made with international experiences and expertise, but when it comes to implementation there is always some aberrations, and it doesn't seem quite to work in practice. Hopefully it will not be the same when it comes to independence and impartiality of the judges, but it's something which is in the end, apart from all the guarantees that are there, it's something that is subjective. And my question to the panel in this case would be, what are the tips or what has worked in other places that make this process as less subjective as possible as well, so the law really worked in practice too? And maybe should I address the second question now? Okay. An important change that was made in the Albanian justice reform was the introduction of on the reasonable term for the judgment, for the ending of a judgment. What happens with the courts was that this kind of reasonable term, the superior courts and the other courts said that it's okay, that it has been prolonged more than the limits made in the law, and the argumentation for this was the justice reform, which normally should be the opposite, because the justice reform should not obstruct the system, but in reality it happens that it was used as an excuse for this kind of obstruction, and it was used as a legally acceptable excuse. So what would be the best solution in this case as well? Many thanks.
Thank you very much, Tirana. I'll then move on to Skopje, please.
Thank you for the inspiring discussion. So far, we don't have many questions or comments by the participants here. Maybe we can only raise the issue about the freedom of expression of judges regarding for instance, commenting on current political affairs or issues. And there are some cases in Macedonia when judges especially use social media to express themselves on political matters. So what would be the position of the court and of the judges regarding this? Thank you.
Thank you very much, Skopje. And then finally for this round, for this tranche, can I ask Sarajevo whether they have any comments or reflections?
Thank you very much for your clear interventions. It seems that the participants have no questions whatsoever at the moment. Thank you very much.
Thank you very much, Sarajevo. We will. I will then turn to my panelists, perhaps in the same order they took the floor earlier, to respond to the points raised so far before I move to the final three hubs. So perhaps I can first ask Robert to reflect on those aspects which you want to reply to.
Thank you, Tim. I think I will only comment on the last question posed by our colleagues in Skopje. I will leave the Albanian issues for Ledi, who knows much more about them than I do. As I said before, judges partaking in societal discussions on topics of political interest is highly problematic. Now, there is always a fine line here to be drawn between judges extrajudicially discussing issues of concern for the judiciary, judicial reforms, and such issues where I think judges have a meaningful contribution to make. But for example, when we are discussing issues of high policy or high politics, which are part of an ongoing and often very tensive social debate, judges do not have a place in that debate. That is the limitation that judges must make on their own roles due to the fact that public confidence in the independence and impartiality of the judiciary is risked by such expressive activity. Now, the legal conclusion to that, I mean, what kind of consequences can flow from that kind of participation by judges is often a complex question. Because usually we are looking at whether a judge is impartial, objectively or subjectively, as described by Tim Eike yesterday, in a particular case. Now, that would usually relate to the particular subject matter in the case or the parties and so forth. It is not excluded that, not at all excluded, that the participation of a judge in a debate on political matters may be so intimately related to the underlying dispute in a case that it would be justified to find that the parties to the case could reasonably call the judge's impartiality into question. And the more judges are having to deal with very difficult disputes between the separation of powers, dealing with constitutionality of legislation, dealing with whether executive action, for example, in relation to the pandemic, are in conformity with human rights or constitutional principles, the more it cautions against, in my view, excludes any deliberation or participation by judges in a topical political debate. Now, here, of course, cultures matter. But if I can, from where I sit, bring any message to my colleagues, my sistren and brethren in the region, it is simple. Stay off social media. Do not tweet. Do not comment on political matters. Your job is to decide cases. It's as simple as that.
Thank you, Robert. Mirjana, do you have some...
Yes, thank you. I will try to answer the first question raised by our colleague from Tirana. And it might be also not only answer, and also it will be a comment. I think you are right. If you will go through the reports of EU Commission, or if you will go through the reports of regional NGOs, you will see that most of the comments are stressing that the laws in the region are with good quality, but the problem is their practical implementation. And how to achieve independent and impartial judiciary without implementing these good laws. The problems are not always internal. It's not the problem sometimes in the justices, in judges, but sometimes the problems are external. It was mentioned this morning that there are all kinds of pressure coming from outside in a form of political criticism, in a form of pressure coming from the journalists, from political debates, and etc. It is up to the judges how they will perceive this criticism. The criticism is very positive thing if it is with constructive approach, if there is a goodwill behind the criticism. So in order to implement good law, it requires judges with intellectual integrity, judges with strong standing, and also it requires clear division of powers, as it was already mentioned by my colleague, Lady Bianco. It's always difficult if there is a pressure coming from outside through political parties, through NGOs, and etc. And the guarantees should be in the form of High Judicial Council. High Judicial Council was mentioned but by almost all hubs in the region. So the High Judicial Council should be a form of link between judges and executive power, between judges and legislator, and they should work on integration of judiciary and on preserving and improving the integrity and independence and impartiality of judiciary. Of course, the key element is the moment of when judges are recruited. So at the moment when they are accepted by Academy for training and educating judges, this is the very first filter where only people with integrity, with knowledge and strong standing should be accepted as a future judges. Then the rest of the work is in the hands of High Judicial and in the case of Bosnia, Prosecutional Council as well. So this is, in my view, important body which should be in constant dialogue with judiciary and with other parts of the government. Thank you.
Thank you, Mirjana. Lady.
Thank you, Tim. Concerning the first question asked by Tirana, unfortunately the answer is not as straightforward as the answer given by President Spano in relation to media, social media. It cannot be so clear. What are the tips for the laws to be applied? You're right when you say that the laws have been adopted with international expertise, carefully drafted in most of the cases. The question is the application since many years. Well, there is not only one tip. There is a combination of tips. Most of them, they've been mentioned these 2 days, actually, how to improve the application of laws in relation to independence and impartiality of the judiciary. There are various forms from the legislative changes, judicial reforms, institutional preparation. Actually, this forum is a tip as well. debates taking place amongst the judges, judicial institutions in each and every country, dialogue between the national judges and the Strasbourg court. All these are tips. The question is that we get the right message, and when you go and do your daily work, you implement those tips and you stay away from any kind of political or whatever outside interference in doing your daily work. So this is the idea. Because if we see, for example, it was mentioned yesterday by Judge Kado, the composition, the law on the composition of the Albanian Constitutional Court is, as far as I know in the region, probably is the best. The first candidate elected, nominated by the President of the Republic, the second by the Parliament, and the third by the Supreme Court. However, we have 7 judges now with the Constitutional Court. None of them has been elected by the Supreme Court, simply because there is no Supreme Court. So you see in the way how you implement legislation and reforms, this brings to bigger questions now, as it is the case of whether Albanian Constitutional Court is established by law or not. Concerning the second question asked by Tirana, the length of proceedings, I raised the issue because, as I said, it was raised last year by the Venice Commission in their report of June 2020 on the Albanian judicial reform. And it is very problematic. Before the Albanian Supreme Court, there are 36,000 cases backlog. They are approaching to 30,000, as I was told this summer, before the Court of Appeal. And the courts of appeal are non-existent in the districts. There is going to be only one court of appeal in Albania, which back in 1998 was considered as a situation which brought to more corruption, having only one court of appeal. Because imagine someone traveling, especially from South Albania, North Albania, to come to Tirana for each and every judicial measure. It also raises issues under access to court. The issue of the compatibility of judicial reforms with respect of length of proceedings has been raised by the court in a series of decisions and judgments. And I recall, for example, Fisanotti versus Italy, and there are hundreds of judgments against Italy concerning the Legge Pinto, the law Pinto, which was drafted with the intention of reducing the length of proceedings in Italy. And then that law in Italy produced even more lengthy proceedings. And the court now, I don't know now, but at the time when I was at the court, the court in Strasbourg produced committee judgments deciding violation in a list of kind of applications, and in most of the cases, the Italian government also provided a unilateral declaration accepting the violation. So my take is that these situations bring, this is why I said it, bring to violations, and the reforms have to be very careful when they're drafted in this regard, in order not to create problems in the operation of the judiciary. Thank you.
Thank you very much, Lady. Before I move on to the next 3 hubs, can I just alert those in the room that after the hubs and the panelists responded, I might open up the floor to the room if anybody here has any contributions. And understand Sarajevo does have a question after all, so I will take you as the 4th hub after Belgrade. But if I start with Christina, please.
For the interesting and very informative speeches. Now I would like to give the floor to Edona Tolaj Ahmeti, who is a lawyer here in Pristina, and has one question for the panelists.
Thank you very much, Floka. My question is related to one of the discussions which was brought up from the hubs in this morning, and has to do with the way that media, civil society, and in general public tends to possibly influence the judiciary across Western Balkan countries, and sometimes even risking to violate the presumption of innocence in ongoing cases. My question for the panel would be, do you recommend or suggest for the judiciary in these countries to undertake as measures in order to best balance the right of the media to gather and to convey message to the public on one hand, but also for the judiciary to maintain its impartiality and independence when adjudicating justice? Thank you.
Thank you very much, Pristina. Can I then move on to Podgorica, please?
Good day. We do not have discussions to propose per se. We do have a question. Our question on behalf of the regional hub would be: what are the considerations of the European Court of Human Rights in terms of effectiveness of legal remedies for the protection of the right to independence and impartiality? So the violation of the positive obligation for the state to protect this right of a judge, whether it's an influence from the outside, from the media or elsewhere, and also I wouldn't count in here the lawsuit for the for the compensation based on non-pecuniary damages. So, in particular, in which situations would you note the non-existence of a national legal remedy that, for this particular court, would be ineffective for the breach of their right to impartiality? So, the legal remedy against the state. So what would be the legal remedy, or a collection of legal remedies that would be effective for the state to be more active in protecting the right that this judge should have in accordance with the law?
Thank you very much. And then I'll ask Belgrade, please.
Thank you very much, Mr. Chairman, and our thanks go to all panelists for the excellent presentations. We have one question. It will be posed in Serbian, and the question will be posed by Ms. Majda Kršikapa. She is an advisor for international cooperation at the Constitutional Court of Serbia. Please, Majda.
Hello, everyone. Well, following on what Ms. Judge Trajkovska said about the importance of training in judiciary, my question is related to the same topic. After these constitutional amendments ahead of us, our legal reform will be taking place. We'll be amending a whole set of pieces of legislation, the law and judicial academy being one of them. Numerous issues have been discussed in this respect. One of such issues is the whether constant training for judges and prosecutors should be mandatory. As far as I know, this matter is regulated in different ways, especially in the countries in the region. In Serbia, continuous training is not mandatory according to the law, except when High Judicial Council issues such decision when systemic laws are amended. So continuous training is not required, not in the with respect to the topics of training or the number of days of training. And lately, we've been also receiving questions or questionnaires, such as the one of the European Judicial Education Network, asking us to respond to the question of whether ethics and integrity are mandatory as subjects in the Judicial Academy, and how many days our judges and prosecutors, how many days of this training they have to complete. So what are the advantages of a regime in which continuous training is mandatory for judges and prosecutors, especially training regarding ethics and integrity? Also, what is the best or desirable number of days, 2 days or 3 days? I know that judges in the region, for instance, they've, they would realize in December that they need to complete, that need to have these 2 or 3 days of training, and that's when they want to do it. That's it. Thank you.
Thank you very much, Belgrade. We had an acoustic alarm signal, so we're not quite clear what we're doing. But while that is being sorted out, I understand that Sarajevo did have a question after all, so I will turn to Sarajevo until we're told we have to evacuate. Sarajevo, you have the floor.
Okay, thank you very much. Yes, we do have one question. So it is clear that there are situations in which judges may and should be involved in public debate. For example, when it comes to judicial reform and the processes related to it. But in your opinion, what happens if members of the High Judicial and Prosecutorial Council, as the independent body, who are also judges, publicly express political views and fiercely criticize their critics? So how cautious, in your opinion, should they be in exercising their role? So I believe this is a short question from the Sarajevo Hub. Thank you very much.
Thank you very much, Sarajevo. I will again turn to the panel in the order they spoke earlier. So I'll first turn to Robert.
Thank you again. I would maybe say a few words about the question posed by the colleagues from Pristina first. What can the judiciary do to retain the independence and impartiality of the judiciary, safeguard the presumption of innocence in the face of media exposure, media discussions about pending cases? This is a tricky issue, of course, because we are there confronted with a tension potentially between two rights, as we know. On the one hand, the media has a very robust right under Article 10, the free expression provision, to disseminate matters of public interest. And that includes court cases, and we have ample case law on that. On the other hand, we have potential individual rights, either under Article 8, the right to private life, rights flowing from Article 6, paragraph 2, which could potentially come into play. It is difficult to give a one-size-fits-all answer to this. It all depends on the factual scenario we are dealing with. But of course here, discussing at the level of communication in general about what are the deontological rules applicable to the journalism, media, and so forth is very important. But I also think there are several member states that have promulgated legislation to try to find at the legislative level, at the statutory level, certain guidelines on where those boundaries lie. Now we have, and even in some state, we have what are called gag orders, which are judicially ordered limitations on media activity in relation to pending cases before courts. For example, in the United Kingdom, there is a tradition of that kind of orders, whereas in the Nordic countries, for example, that is not a tradition we have. But there are quite robust deontological rules by the media, which are actually regulated to some extent by government organs when complaint mechanisms which can come into play. So unfortunately, it's very difficult to give one answer to this because, as I say, there is an interplay between clashing rights potentially in this field. I would also just comment on the question posed by Sarajevo, and then I'll leave other questions to my colleagues. I think Mirjana will probably also say something about that question. Members of judicial councils, well, judicial councils in the traditional sense, are of course members who are there to safeguard the independence of the judiciary. That's the raison d'etre of judicial councils, if they are properly constituted and they are doing their jobs. So that means that members of judicial councils are as such, can be participants, and one would even say should be participants in a meaningful debate about the judiciary and potentially be in a position to confront unreasonable criticism against the judiciary and individual judges. It is not acceptable, in my view, when judicial councils and judicial council members start to be the proponents of unreasonable criticism against judges. That is circumventing, and we then see judicial councils working against the main purpose for which they are constituted. But of course, the details here are all, you know, the nitty-gritty of an individual situation is very difficult to comment on if one doesn't have a particular situation in front of one. But it is clear from examples we have seen that when judicial councils, because they may consider that they are in a situation of having to promote some kind of governmental policy which is not commensurate to protecting judicial independence, then that kind of actions, measures become very problematic. So yes, Judicial Council members should be and should have the opportunity to be part of a public debate, but they should then, that public debate on their part should be to reinforce, to safeguard, to protect the independence of the judiciary, not the inverse.
Thank you, Robert. Mariana?
Well, thank you. First of all, concerning first question that came from Hub in Pristina, I will just add some elements. I think that it was already answered by President's panel, but please look into the case of Vedat versus Switzerland. It is about media and the presumption of innocence and how media should not react and how media should not, let's say, influence judiciary while the case is still going on. Well, we have seen different models in different countries in the region, how courts are coping with transparency and how they are trying to inform public through media. One good example is also European Court of Human Rights. You will see that there is always fresh information as soon as the sections or the Grand Chamber will come with a new case, and there is a press release which is very useful for the journalists, and they're using these press releases and legal summaries published by the court. I think that it's always good for the courts to learn how to feed the public and media with information in advance, because it's always the worst situation and worst scenario is then if the media will start to speculate. Of course, they have duty to inform, and also the court should find proper ways how to reach them and how to inform. But of course, it's not always easy to achieve this. When it comes to the question raised by Magda Kršikapa from Belgrade, I think that training and education of judges is one of the key elements for achieving better visible independence and impartiality. And your question is about the possible change. It's linked with the constitutional changes, and we will see how this will develop in Serbia, because as we've heard, the working group is still working on constitutional amendments. But let me say that there are already good practices in the region. Some of the academies are working on the basis of training and educating judges, and judges are obliged to fulfill a certain number of hours per year, and it's true, usually in the end of the year they are probably pressed to fulfill this let's say quota in a way to be better evaluated in the end of the year. I don't know, is this a good model? We will have to see what are the real results in practice. But I am always in favor of training and educating judges, and the academies, I think, should focus on finding educators and trainers which will attract attention of the judges. For example, you cannot expect that judges from Supreme Court or Constitutional Court will participate in training if you are bringing as educator or trainer judge from basic court, or so there should be some, let's say, criteria in choosing who will present a certain topic. So And when it comes to the question from Sarajevo, I would also like to add some elements concerning High Judicial Council. In my view, High Judicial Councils should be even more visible in public. Members of the High Judicial Council should be actively involved in reforms concerning judiciary, because they are presenting judges in front of Ministry of Justice, in front of the Parliament. They should speak in the name of judges. And this will bring also integrity to those bodies. They should not be perceived only as someone who is punishing judges, dismissing judges, responsible for disciplinary procedures. High judicial councils are meant to be guardian of independence and impartiality of the judiciary, and at least leading persons, presidents of the High Judicial Council should be actively involved in public debate. And in the end of the day, this is the case of Baca versus Hungary. Baca was active in public debate concerning reforms, not only as a president of the Supreme Court, but also as someone who was member of the High Judicial body in Hungary. So I will stop here and leave some space for Lady.
Thank you, Mariana. Lady.
Thank you, Tim. I'll reply only to the question about the effective remedy that was asked by someone. I've noted probably Kosovo, Sarajevo here. The question of effective remedy and the independence of the judiciary has been already dealt by the court, as it has been also mentioned during these 2 days. The principle of irremovability in office of judges is one of the main guarantees that the tenure that secures their kind of independence and impartiality. So if a judge is removed in various forms for various kind of in the framework of different procedures, then there have to be guarantees. These guarantees, so the role of the other institutions is that they have to provide the legislation in that regard. And for example, the case of Baca that was just mentioned, the court raised this issue and said that the domestic proceedings were such that the Hungarian authorities didn't kind of offer any kind of example that there was such a possibility in the Hungarian system, and it found a violation in that regard. Or there is a case from the region, Panovic and Milivojevic against Serbia, where the interruption of an elective mandate was not controlled by a judicial authority, then was found a violation. So the principle is that every time there is a measure for the interruption of a mandate of a judge, there should be a control by a judicial authority or an authority exercising judicial functions. And in that regard, for example, I would praise the role of the Venice Commission, because I remember that the Albanian judicial reform in the first draft provided only the first level, the qualification commission. And then the draft went to the Venice Commission. It was a copy of the 1998 reform. And it was thanks to the Venice Commission, which was introduced the appeal chamber, and the Venice Commission insisting that it should be a body with judicial characteristics deciding over the appeals on decisions taken by the Commission. So this is the principle. You can see Baca, Camelia Bogdan. You can see the recent judgment Lucifer versus Belgium. Paul, do I pronounce it correctly? More or less. Is a judgment of this July, where the court deals with this issue again. So this is my reply to this question. Thank you.
Thank you, Lady. And perhaps adding in terms of remedies, of course, from the party's point of view, the primary remedy, before one looks at disciplinary sanctions and the like, should be the appeal court. The right of the party to appeal on the basis that the judge below was not independent or impartial, which in a sense should be the fallback and should be the starting point, rather than immediately thinking about disciplinary sanction, because it's the judicial control even of the requirements of independence and impartiality, which is so essential before we get to into the disciplinary realm. As I promised, I will now, I'm looking around the room whether there are any comments, reflections on what we've heard from within the room. Paul Lemons.
Okay, thank you, Tim. I would like to say something. It's a more general idea that I have. We have been talking for 2 days on how to improve the independence and the judiciary, the independence and impartiality of the judiciary. We have been talking the whole time about the confidence of the public in the judiciary. A number of topics were also discussed this morning. Of course, there's a responsibility for other actors than the judiciary, the legislature and the executive. But there is also, and that has been stressed various times, yesterday and today, a responsibility of judges themselves. Now, we have talked a lot about the quality of the work of judges, the professional aspect, the knowledge of the law, formation. For me, training would have to be mandatory. The reasoning of judgments show that you have listened to the parties, that you have understood their arguments and that you have dealt with them, a certain diligence so that you render justice within a reasonable time. We have discussed all that. But I think there is also a more personal requirement relating to the conduct of judges. Montesquieu spoke of the three powers, the legislature, the executive and the judiciary. Maybe it's not entirely correct for us to think always in terms of the power of the judiciary. I think that the judiciary is more at the service of the citizens. And that should, I think, be shown. It should not only be done, but also be seen to be done, to paraphrase an expression. I think that judges can show that in the courtroom by treating parties in a polite way, treating them as parties, and sometimes we know examples of judges who have not been doing that, but also outside the courtroom. And I think that it's very important for judges. We've heard about corruption and so on, the perspective of corruption. Well, judges can also show outside the courtroom some modesty, some soberness. I think all these things can help to improve the confidence of the public in the judiciary. And I think that ethical rules could also develop this perhaps a bit more, say what is expected as far as the personal conduct, but with appearances for the outside world, what that could contain. That is all I wanted to say. Thanks.
Thank you very much, Paul. Is there any other comments or questions? It doesn't look like it. So I've been told that unfortunately we don't have the time to go back through all the hubs. So I've been asked to wrap up. Before I do, can I just, from a personal point of view, thank all the hubs and all the participants here and the organizers for a very fruitful and deep and informative exchange of views. It is a shame, as some speakers have already said, that we can't be together. As I said yesterday, we're a bit closer to it, and hopefully next year we will be in the same room again, because these exchanges always take place at multiple levels, and it would be nice to be able to follow up on some of the discussions also in bilateral conversations outside the hall. But from a personal point of view, my sincerest thanks to everybody for all your hard work on this.